about 10% of Kenyans have a written will, yet most of us hope our families will be protected if something unexpected happens. But between a will and a trust, which one truly reflects your wishes? Think about your own situation. If something happened today, would your loved ones know exactly what you wanted, or would they be left guessing? In Kenya, more than 30% of probate cases come from unclear or contested estates, showing just how often families end up in courts. Despite of this, most people still don't understand what separates a will from a trust. As more Kenyans buy land, build homes and invest, estate planning has grown by more than 25% in just 5 years. Yet confusion remains. Some believe they don't have enough to plan for, while others fear choosing the wrong tool. So, if you had to decide today, would you pick a will or a trust? And more importantly, do you know what that choice means? Your choice determines how smoothly your assets move, how much control you keep, and how private your affairs remain. Yet, despite how important this is, many Kenyans still don't know who would step in to manage their wealth if they weren't here tomorrow. This is more than a legal question, it's a family question. Today on Financial Clinic, Sally Limo sits down with experts to break down the real differences between wills and trusts and the questions every Kenyan should ask before choosing either. Because planning your legacy isn't just for the wealthy, it's for anyone who wants their story to end the way they intended.
Wow, a very good morning to you on the 19th day of November 2025. And indeed, just like the explainer has asked, do you know what choice you need to make when it comes to protecting your family, protecting your wealth? You know, this morning I'm super excited to be joined by an amazing panel, and we'll be discussing about matters will and versus trust, which one is more important. But before then, I just want to remind you that to be part of this conversation, you can do that by just plugging in on 20316, our SMS line, where you can send in your questions, you can send in your concerns, and also 0786 316 316. That is our WhatsApp line. Be part of this conversation and let's learn together. The experts are here, so you have free consultation when it comes to this amazing topic. And remember, everyone wants their loved ones to be protected and their wishes honored. But how do you make this happen? Wills and trusts are part of the tools that actually make it possible. Today we'll break down what each of them does and the key differences, as well as help you figure out which one makes sense for your family. And to help us unpack this very important topic is the Managing Director of MTC, Mr. Abel Munda, as well as an advocate who understands the legal aspect of this better, Isaiah Munje. Welcome, gentlemen. Thank you so much for making time to be here this morning. I'll just give you an opportunity to introduce yourself. I'll start with you, Akili, then the MD.
Thank you, Sally, for having me. My name is Isaiah Ndisi Munje. I'm an advocate of the High Court of Kenya, and I run a fully fledged law firm in Westlands. I'm the immediate former county attorney of the county government of Tana River. And in the law firm, I deal with real practical issues, the constitutional matters and family matters.
Karibu
Thank you so
sana.
much for having me.
Karibu, Abel.
Thank you, Sally. Thank you for having me. I am the Managing Director for MTC Trust and Corporate Services. So in the company, we deal with trust matters and various lines of businesses. If I can just mention a few. I mean, we deal with family trust, mainly the topic for today, but we also have other lines of businesses. We, for example, act also as trustees in security trusts. So where there are, for example, multiple lenders, you need a trustee for that. We also do securitization, where you need to ring fence future income streams to take care of the lender's interest. We also, of course, act as trustees for retirement benefit schemes. And we act as an agent for ESOPs and escrow. Yeah, where somebody, of course, is carrying out a transaction and they need to pay money. So before the condition precedents are met, then we take care of that money. So in a nutshell, that's who we are.
You're doing an amazing job, very important, you
Yeah.
know. And
Thank
so
you.
to start us off, then I think we'll just start with you, Abel, right there. In very simple terms, what is the difference between a will and a trust?
Thank you for that question. So a will is simply a document that you will draft to indicate how you want to share your wealth in the event that you pass on.
Yeah.
Yeah, that's basically what a will is. It is simpler in nature, and it is of course important to have.
Yeah.
But there are certain advantages and disadvantages that I'm sure we'll delve into.
Yeah.
A trust is different in that you have to pass on the title of your properties,
Okay.
yeah, to the trustee. So you settle that the properties or whatever assets you have into a trust, and the trustee now becomes the owner of those assets.
Okay.
But the difference, the big difference is that a trust is basically, you know, a living document. So you can actually set it up
Yeah.
while you're still living. It can take effect while you are still living, as opposed to a will which will take effect
After
you know,
post.
yes,
Yeah.
you know, on your death. And the trust, because you've passed on the title, it can hardly be contested, because now the title belongs to somebody else.
Yeah.
But you'll then indicate how you want your assets to be distributed into the future.
Okay.
Yeah, and there are some, obviously, there are some aspect of it. For example, you can appoint or nominate who we call a protector. Now, a protector is just to make sure that you are doing or distributing
Yeah.
the assets in accordance to what the settlor wanted. And settlor in this case is the person who settled the assets into the trust.
Okay.
It is could be looked at as being a better structure for let's say if you have many assets that you want to settle.
Okay.
It's obviously, I would say, bigger assets, because a will, you can do a will, and sometimes people do both, you know, because the will can take care of the simple assets. So a car, for example,
Yeah.
you know, you can actually include that in a will.
Yeah.
You know,
Okay.
a watch, jewelry, stuff like that. But when you come to big assets like now a house or a business that is running, or financial assets, you have big financial assets, those you can include into a trust.
Okay.
And also the good thing with a trust is that it will take care of the interests of your beneficiaries, even in cases where there could be disputes. So with the trust, you know, the disputes are handled because, first of all, there is quite a lot of confidentiality. And if you have indicated properly how you want the distribution to be made,
Okay.
that is how it will be made. That is how we will stick to that.
That is
Yeah.
how it will be made, and
Yeah.
that's legally that way. Wakili, just to bring you into the conversation, I don't know if you have anything to add to what Abel has said.
Yes, Abel seems to have summarized everything about wills and trusts.
Yeah.
So in terms of the legal context now, the wills, we have a law in Kenya called the Law of Succession Act,
Yes.
which technically repealed all existing laws prior to 1981. And a will definitely is defined under Section 3 as a declaration
Okay.
of a person's intention of what will happen upon their death. So just to add to what Munda has said, a will takes effect after you die.
Okay.
A trust, you can use a will to create a trust.
Okay.
You can use a will to create a trust, what we call testamentary trust. There are two types of trust. You can have a testamentary trust or what we call a living trust, which Munda has referred to. So basically, to add to what he has said, is that a will is a tool for estate planning. A trust, on the other hand, the regime of law that governs trusts, we have the Trustees Act, and we have the Trustees Perpetual Succession Act. But again, we also have the same Law of Succession Act.
Okay.
And then you will find that there are other complementary laws that dictate or talk about wills, wills and trusts.
Okay.
For example, you'll have the tax regime and you'll have the land laws. So all those complement the tax, the wills, and the trust relationships.
All right.
Yes.
Fantastic. When we speak about the wills and trust, Abel, then you look at, the question would be maybe how important is it for someone to start using these tools early in life? Because the people really wait up to probably late, and you're seeing my sunset years are here, then maybe I should start now. Is it important to start this early?
It is very important to start this early, particularly the moment you start having assets. You know, we often wait and we think it is only for the wealthy or those who have accumulated assets, but you need to start immediately. You buy a car, you need to will that car, for example. I know there are some cultural hindrances. For example, there was one time someone was sharing with me that if they do their will, then it's like they're ready to die.
Exactly.
But you need to plan. You've seen how sometimes somebody has passed on and then people clamor for the assets in the absence of a will.
Yeah.
So these are tools of estate planning. As you grow into in that journey, for example, of asset accumulation, and you have to determine, for example, which structure is best for you. I believe, having worked now for a trust company, I believe that trust is superior in some aspects to a will, particularly if you have now accumulated a lot of assets. And you know, you can have a situation where, for example, you are willing your assets, and there are several siblings. Some may be somehow challenged in a way.
Yeah.
How sure are you that these other siblings will take care of the interest of those their siblings who are, let's say, challenged?
Right.
How sure are you that they will even pay fees or buy medical insurance or other expenses? How sure are you that they will cater for those? And even if they are still young, and maybe you can will to you know, a guardian, for example, you know, and normally that is the worst, because the guardian normally would take off with the amount and leave leave the kids without anything. So this is where the trust comes in, because a trust, once you have settled your properties into a trust, a trustee will live according to that. So if you want school fees to be paid, if you want medical expenses to be taken care of, you know, and according to me, I would say that a corporate trustee is really the best way to go, because with a corporation you have directors. This is we know that a company, you know, will exist, you know, into the future. So what you need to determine is how, you know, credible are the directors, how steady is the company. So Wakili here mentioned about the Perpetual Succession Act. I mean, you can set up a trust. Anybody can set up a trust, and you appoint the trustees. You know, but we have known of cases where this has gone so badly, where people, you know, appointed, let's say, their friends or family members. So as human beings, sometimes there are likely to be some biasness.
Of course, and greed checks in as well.
Yes, yeah. So in order to protect against those kind of issues, one should consider a corporate trustee.
Okay.
Yeah.
When you speak about that, consider a corporate trustee, fine, and you've mentioned some of the things maybe one needs to look at to know that this is the right corporate trustee. But when we talk matters legal, how then do I know this is the right, like if I come to you, how will I know that this is the right guy to help me through the, you know, picking either trust or a will, you know, legally? How would I know?
They normally say when you are informed, then you are able to make a decision from the point of being informed. And being informed entails looking at the advantages and disadvantages of the wills. Now, if, for example, you want to deal with assets that are spread across the globe, different jurisdictions. You can't use a will, but remember you're dealing with different laws, you're dealing with different tax regimes, and you may end up spending a lot of money. And if your assets are in one jurisdiction, for example, now in Kenya here, you can decide now, let me go with the will.
Yeah.
But now what are the advantages of this will? And as Munda has said, it's easy to set up. It's not costly compared to the trusts. But remember, each of them has legal threshold. What amounts to a trust? What do you need to do for something to qualify as a trust?
Okay.
There's this perception that trusts cannot be taken to court. But remember, when you go to court, there are certain requirements that qualifies something to be a valid trust and something that qualifies to be a valid will.
Okay.
And even for wills, there are wills that you can just produce orally, and there are qualifications and requirements for them to be recognized in court. And there are those ones which you reduce into writing.
Okay.
And there are requirements for each of them. So when you are informed and you go to somebody like Munda or an advocate who has experience on the landscape of family law, specifically on succession, then you're able to be given the options of what you need to do, and from there you make an informed decision.
Okay.
Yes.
Maybe Munda, you can take us through how then does the trust work? You have mentioned it a bit, posthumously, as well as, you know, when you're still alive, because you know, you can still use it when you're still alive. How does that work?
Yeah, I'll get to that, Sally. But one thing I wanted to mention about wills, we know that to effect a will, there's a process called, you know, probate. You have to go through a probate process. And this probate process can take a long time. Sometimes can run into years. We've had cases even here in Kenya where it can run into years. At that point in time, you don't have access to those assets. You know, so that is could be some of the disadvantages of having of doing a will as maybe as opposed to a trust.
Yes.
But a trust, like Wakili says, I mean, if the formation is valid and it is a valid trust, even you, the settler, the owner of the assets, you can actually benefit from a trust while living. So this is what it means by you know, it's a living.
Exactly.
Yes. So and even the distribution can be made. You know, as the person is living. I mean, we have cases in our office, for example, where every month we pay money to you know, a settler. This is somebody who settled their assets into the trust, and they say every month, just, you know, pay me this. In the event that I'm not there, do this. You know. And in the event that this other person is not there, do that. So it actually can go into generations. And then you can also say that, you know, after 20 years, you can dissolve it, you know, and distribute it like this to my grandchildren or to my great-grandchildren. Yeah. So it is the best way to secure the future of, and pass on, obviously, with love. When your grandkids look back and they are enjoying those assets, they will appreciate the love that you had for them.
Absolutely.
To have done something like that.
Absolutely. I think actually that's more of love than any other thing. You can't love someone much more than that, just protecting them. When you look at the trust, then, do you think it offers more protection when it comes to creditors, business liabilities and stuff like that?
As I said earlier, there are trusts that are created under a will. And then even within the regime of trusts, it depends also on the trust that you create. There's what we call revocable trust, and the one which is irrevocable. So when you create a revocable trust, what that means is you maintain the control of your assets. And when creditors come, they can access and attach your assets. But now the irrevocable trust, what that means is now that property, you decide to transfer it. You divest yourself of the ownership of the property.
Okay.
And now that trust becomes a separate legal entity from you. You can be a beneficiary of that trust. And that's what Munda says, that when you create a living trust, It means out of that trust that you have created, you can become a beneficiary, a living beneficiary of that trust. So you're benefiting from the trust when you're still alive, as opposed to a will, but no one can come to you if you owe them money to take your property, because you have divested yourself of the ownership of that property.
Okay.
But now the trust which are created under will, what we call the testamentary trusts, they have to be subject to probate. So you have to go to court, and once probate is complete, that is when now they take effect. And with that kind of trust, you are able to appoint your trustees who is going to take care of these assets or the property when you're gone.
Okay.
But remember, it takes effect after you're dead, as opposed to the one that is created under the trust deed, which is a living trust.
Okay.
So just to add to what he has said, the trust that you create depends also on your portfolio of assets.
Okay.
You could be a person living here, but you have assets in other jurisdictions. Or you could be living out of the country,
Right.
and you have assets in Kenya. Or you could be a foreigner, but you own a property in Kenya. We have so many foreigners that buy properties here in Kenya, and they have limitation as to how they want to manage those assets when they're out of the country. So again, it boils down to what I had said earlier, that based on the choices that you have and the asset portfolio that you have, you can decide then to use assets, the trust with its advantages, and wills with its advantages and disadvantages.
Okay.
Because when you go to, let's say for example, you have assets in more than one jurisdiction. In Kenya, we have something called resealing of grants.
Okay.
So let's say for example, for probate, you decide to do a probate process here in Kenya, and you get the grant, but you have other properties in another jurisdiction, maybe Uganda, or maybe you have it in the UK. If the jurisdiction is that of Commonwealth countries, all you simply need to do is to take that document from the court here, take it to the court in that jurisdiction, and they do what we call resealing.
Okay.
They seal it again, and it has legal effect in that country.
Okay.
So you don't have to go through another parallel process in that country.
All right.
But if you do not, if it's not a Commonwealth country, what that means is, that is if you choose a will to dispose of your, or to manage your assets after you're dead in other countries, you will have what you call a mirror will. Here in Kenya, you have a will, but now you go to those other countries, engage local experts because they understand the local laws in those countries.
Right.
Then you also make wills that comply to their laws in those countries. But now this one is called a mirror will, the main one that you make here in Kenya. You will mention those properties in this will. But as to how they will be managed will now depend on that local law.
Okay.
Now, for trusts, you could decide to register an offshore trust where you go to tax havens, those countries that their tax regimes are a bit friendly.
Okay.
And we have quite a number, Mauritius, New Zealand, whichever you choose. And then you decide to consolidate all your assets into that trust that is registered in that jurisdiction. So with that, you also avoid the elements of double taxation.
Right.
You are taxed in each and every jurisdiction, but once you register them as offshore assets, then you need to, it becomes now advantageous to you.
Okay.
That's why I was saying from the very beginning, you must get proper advice based on your situation. There's no first-hand rule of either you want to choose a will or you want to choose a trust. You can use both. But each of them has their own pitfalls.
Okay.
Yes.
And the experts are here to actually, and you're helping us really understand this better.
Yes.
When we talk about, or we talk about individuals, what happens when there are multiple dependents, Abel? And which one do you think works better? I'm sure someone is watching, they're like, okay, somewhere I have multiple dependents. Should I do a trust? Should I do a will? Which one would give fairness to the dependents later?
Honestly, I think if there are multiple dependents, I would go by way of trust, irrevocable trust.
Okay.
Like, that's what we do at MTC.
Yeah.
And for there not to be, controversies, particularly amongst the beneficiaries, you need a trust. What I have realized is once you've settled your assets into a trust and you've told us who you want to be paid or how you want them to be paid, that fact remains confidential. We are under no obligation to divulge that information to anybody. I mean, we can have cases where somebody comes, well, I want to know how much my father bequeathed to, my other siblings. We are under no obligation to tell you that. You just get what your father gave you.
Yeah.
This is what your parents said, you would have.
Yeah.
And they had the right to do that. Sometimes you may not share your wealth equally because maybe some of the people could be wasteful, and not have regard to their other siblings. So as a parent, you know your children,
True.
And what I see also mostly is parents are normally concerned about their grandchildren. So sometimes you can even find a situation where they bypass their children and bequeath to the grandchildren.
Right.
But they want the grandchildren to be educated, they want them to live a good life. At least you've provided for your children, you've taken them to school and all that. So we sometimes see that kind of a situation, or you really define how you want it, but we will, there is what you call a letter that you will give us how you want the wealth to be distributed.
Okay.
I mean, we'll help you, of course, with the drafting. So once you come to our office, if you are interested in setting up a trust, then we'll, run you through the process. Often people think setting up a trust is expensive. I say it is relative because so long as the assets in the trust is able to take care of the costs of running the trust, you are okay. And when people come to our office or when we are discussing these matters, I would say that it's not expensive in absolute terms. It is relative how much you buy. Of course, you have to pay some fees because there is the admin costs and all that. So you'll have to sort out those ones. And the assets of the trust or the income that the trust is generating should be able to take care of those expenses.
Okay.
Yeah.
Wow. We need to take a very short break and then we'll be right back for this very important, timely conversation, I believe. But Okili, I'd want you to speak to maybe someone who's maybe they've remarried and they're also kids from a previous relationship. How do the two then handle or accommodate this particular situation? Yeah.
That's a very interesting
Let's
point.
get, can we get the response after the break?
Yes, that's
please?
fine. That's
all right.
all right.
Yeah, so there we are. We're going to take a very short break. And remember, we are still discussing matters, wills and trust. And I'm here with experts, Abel Munda, the MD of MTC Trust, as well as Wakili Isaiah, who are here helping us to unpack, understand. And really, this is a free consultation, like I had said earlier. So if you have any questions, remember to ask them on 20316 SMS line 0786316 That is our WhatsApp line. Let's learn together, and we'll be right back after this short break.
My name is Chiku Shiraku. I'm a born-again believer. I love the Lord. I've been working with the Lord for many years now. I love being at home with my family. I also love hanging around with my friends, but I'm more of a homebody. I love to be in the house. I remember us sitting together as a family, watching Dr. Phil. Back then, it was Dr. Phil in the early 2000s. He used to come. It was very interesting. And we would eat dinner together and watch Dr. Phil. And my mom also at the time, she would love to watch Joyce Meyer and T.D. Jakes back then. So those have been household names in my home. My favorite has always been Pastor Joseph Prince. I love his teachings on grace, especially. Everything he teaches just agrees with my spirit. you don't need to work for your salvation. You don't need to work for your blessings. Yeah, these are things that come to us in any case. We give so that the money doesn't own us. We give it because the Lord has given us financial resources as stewards. Yeah, He's given us to steward that towards the kingdom, and so I have been very blessed. Even you just give joyfully, and because before I would sit down and calculate, but I decided no. Why? Let me just give. Yeah, and it has been very fulfilling for me. I never sit down and really count it how it has been, because since I've been giving, and since I've been giving to the ministry, family media, I've been giving to the church, I can honestly say I have not experienced financial lack in my life, in my adult life. Since, let's say, I've been 20 years old going on, I've not experienced it. The Lord has always provided more than enough.
We invite you to become a partner with us by making a donation to M-Pesa Paybill 316 with your phone number as the account number.
The walk of a believer is a walk of faith. And the walk of a believer is a walk of giving. You have to be generous. And God asks it of us not because He's bad or He needs it. Yeah, it's because He doesn't want it to control us. He doesn't want the finances to control us. So you give from what He has given you, and you give cheerfully, right? You don't need to whatever God has placed in your heart to give, just give that. Just give that according to what you have. If you start really calculating the cost so much and everything, for me, that's recently, and it comes, it comes also from a point of revelation. Giving comes from a point of revelation. It's because you see, what has the impact been in my life? What has the Lord done for me?
Amazing. Welcome back. We're just having a discussion around it. I think this topic should be like for 2 hours. I always say there's some interesting topics like this where we learn, the MD was telling us something here, the lawyer, we are all, I'm amazed. In fact, I'm telling them, I thought I'd researched on this topic, but man, I'm also learning. Remember, 20316 SMS line, 0786316316. That is our WhatsApp line. Send in your questions. And there is actually some feedback on our platforms. But before then, remember, for you to be a partner, for you to just be part of this ministry that is helping us reach out people with such important, life-saving, information, you can do that by sending the word partner to 316, SMS line 0786316316. That is our WhatsApp line. And also, just to support or collaborate with us to be part of this, you can do that on paybill number 316, and account name is your telephone number. And back to our, conversation, the social media. I'm seeing the first person here. This is an informative discussion, and I'm glad you're having it, since I have had many questions around wills and trust. To Akili, how can one handle a situation where the deceased had a secret family with children involved? Does a will or trust manage this better? And that, I think I'd asked you just before the break. Also, what should I be keen on when choosing a lawyer or trustee to manage my estate? Then to the MD, how does the trust allow for detailed control over asset distribution and beneficiary conditions that wills may not? So Akili, we'll start with you. How then does the deceased, if he had a secret family with children, does a will or trust manage it? Which one manages this better?
If you are having secret family, we have Section 29 of the Law of Succession Act that talks about who a dependent is. And all you need to prove is that you are depending on this person as and when you are alive. So a trust would be better to manage such situations where we have complex families or blended families. Because you could be coming in and you, the settler, the owner of the property, you are the one who knows those people who are directly dependent on you.
Yeah.
Some of them may not even be your relatives. But in your absence, there are people who may come and say, on what capacity are you coming in to claim ownership of the estate or entitlement to the estate?
Okay.
So if you decide to go the will route, as we said, the will is subject to the supervision of the court.
Yeah.
And there are certain requirements that, if not met, the will be invalidated.
Okay.
And the distribution will be done according to the court process. So it means as much as you have what we call the testamentary freedom to distribute your property the way you want when you're alive, there are certain safeguards that must be taken care of. So if the court, for example, decides, like before, you have daughters, and you decide not to give daughters land,
Yeah.
or you just decide you had someone whom you didn't like,
Yeah.
and you decide to disinherit them, or you just decide to give all your properties to one person and leave every other person without property, the court will look at the circumstance under which you made the will. As I started, I said, but there are two types of wills. There is the oral will and there is a written will. So the oral will has its own safeguards. You make it and you have to die within 3 months. That is now for oral wills.
Okay.
You make it, the period that you're given is 90 days. It gets invalidated after 90 days,
Okay.
except when you are in the military,
All right.
or if you are in this place of active combat.
Okay.
You can make it today, then you are posted to a place that is not safe, and in the process you die maybe on the 4th or 5th month.
Okay.
It will still be valid. But there must be 2 competent witnesses who are there when you are making the will,
Okay.
to attest and say, I was there, I saw him making the oral will. And when I talk about competent, it means this person must be
Of sound
above
mind.
18 and also of sound mind. Of course, written wills also has to be signed.
Okay.
You have to sign it,
Yeah.
or tell somebody to sign it for you. And there has to be witnesses who will also sign
Okay.
to say that I saw him signing, or I saw him ordering so and so to sign for him,
Okay.
for it to be valid. So to answer the question directly, in situations whereby you have a secret family, it is better off you go the trust option.
All right.
But remember what Monda said, there are cost implications of running a trust.
Yeah.
Because these people who are administering the trust must be paid. You probably agree they are paid monthly, they are paid quarterly, but they have to be paid.
Right.
And again, depending on the size of the estate, some may not justify having the trust.
Okay.
So I think that better answers the question.
The first question.
The first question.
Yeah, let me bring in Mr. Munda so that he can respond to this. To the MD, how do trusts allow for detailed control over asset distribution and beneficiary conditions that wills may not?
Yeah, thanks for that, Sally, and thanks for the question, whoever is asking the question. Now, when you set up a trust,
Yeah.
there is what we call a letter of wishes. And in the letter of wishes, you will detail how you want the distribution done. And of course, as part of the process of setting up a trust, we'll assist you to draft the letter of wishes. Sometimes we see people come, they go again, they study it, they come back, they want to change this, they want to change that. You know, that is all agreed. And you can change certain things before before your demise.
Yeah.
So that's okay. And then we have. We always advise that you have someone called a protector
Right.
or an enforcer. This ordinarily would be somebody who has been very close to the family, can be a family friend, can be your trusted friend.
Okay.
They can only for example, oversight for you. But they cannot make decisions, but they can just make sure that we are doing this thing according to your letter of wishes, according to what you wanted, so as to preempt, for example, any disputes. I can give an example where somebody settled assets into a trust. The children were still very young. When the children come of age, they want to disagree with what the parents, for example, are done. And they say, the parents had probably said that this is to take care of school fees, maybe to a certain extent your living expenses, medical expenses and all that. And now you want to come and say, I want to buy an exotic car, for example. Why can't I do that? Or I want to. So to resolve such issues, because we don't want acrimonious relationship. So to resolve such issues, you bring in an enforcer or you bring in that protector and would advise that no, that was not the intention of your, So just to be able to run it smoothly. Otherwise, the trustee, who now is us, we have powers, particularly when you set up an irrevocable trust, we have powers to run the trust according to the wishes of the settlor.
Okay, fantastic. Wakili, someone says now, what should I be keen on when choosing a lawyer or a trustee to manage my estate?
I think Mwenda has answered it better. You look at, number one, it could be the relationship that you have with the person.
Yes.
And for a lawyer, there is that element of expertise. Lawyers specialize in different areas. There are those who specialize in constitutional law. There are those who specialize in family law. Of course, with forums like this one that we are having, you're able to know or find out who to approach. But you see, the good thing about a will and a trust, it gives you the opportunity to manage your estate, to plan. You choose, who do I want to take care of? Who do I want to appoint as trustees when I'm gone? Or if you have children who are below 18 and you want their affairs taken care of, who among my friends or who among my relatives do I think would better handle this as if I am the one who is handling it? So all that again depends on the information flow that you have. There is, I cannot say this is the way to get the person to help you. But remember, when you're alive, you're the person who knows who can better do A, B, C, D in your life. So for a lawyer, of course, there are better places like now this one, where you can decide and say, I can decide to go to Monda because they deal with the corporate trusts. The legal aspects, you want to go to Isaiah Munje because he's a specialist in trusts and wills. All that depends on the choice. But again, you have that power within you to choose who to go to.
So important, of course, to even go, background checks of like
the due diligence, the background check,
and all that, isn't it? Okay, then.
And Sally, maybe if I can just add on to that, we always advise that you have your lawyer, okay, to help even with the drafting of the documents. We review because, for example, at MTC, we have in-house lawyers. We have 3 lawyers. We have, 4 accountants. We have several admin staff to provide support on an ongoing basis. So the lawyers we have internally will review. And normally there is back and forth exchanges just to make sure that the document is watertight, is properly done.
So you advise for me to come with my own lawyer, then you also counter check what we have.
Exactly.
Fantastic. Someone says here, it's Esther from Kitale. Good morning, Sally. Please ask our guests how to handle this. Deceased man left behind 3 women, not legally married to any of them. Wife 1, 1 child. Wife 2, 4 children. Wife 3, 4 children. Didn't leave a will. Property, 2 cows, 1 plot, and some money on M-Pesa. Esther from Kitale. How can that be? I think she just wants to understand then, how can this be distributed? Wakili.
Okay, I think in the absence of a will, and now that is what we call intestate succession. So that will have to go to court There are documents that you need to file in court. For example, you need to have the death certificate, the proof that the person is no longer there, and then you need to have the asset schedule.
Okay.
Now, if you look at Section 29 of the Law of Succession Act, all you need to do is to prove that when this person was alive, so-and-so depended on him.
Okay.
And who are the beneficiaries? Who are the dependents under Section 29? It means you can be a wife, you can be a former wife, you can be a parent, you can be a grandparent, you can be children. The list is long.
Okay.
But what matters, whether or not, marital status notwithstanding, your children are your direct dependents. So when you die and leave some properties, according to the Kenyan law, you cannot deal with the property of a person who is deceased without the court intervention.
Okay.
If you do that, there's a criminal element to it. So the moment the person dies and you know his properties, you go to court and go through the process called intestate succession. And as a family, you should have had in your mind who you would prefer to administer the estate. It could be those women, if there are 3, the maximum is 4. So you could say, I want the mother of each of these children to be the administrators.
Yeah.
Or the mothers can sit down and appoint one of them to administer the estate on behalf. Remember, you're given the role of a trustee. You are administering on behalf of these people, not for yourself, and you're answerable to the court.
Okay.
So that means without a will, you just have to go to court, and the court will now manage the distribution of the estate.
All right.
Yes.
You know, sometimes it's a bit embarrassing that we find the big guys, even a vice president, that we've seen a story on TV, their children are suffering. I don't know what happens when, you know, so it's not about the money like we had said earlier. It's not about the wealth that you have. It's about just getting the right information. Then there's David from Nakuru. David is saying, Shalom, kindly explain the requirements for setting up a trust for inheritance documents, costs, and who qualifies to create one in Kenya. That's David from Nakuru. Thank you, David, for that. April, you can respond to that?
Yeah, anybody really with assets qualifies to set up a trust. Yeah. And in terms of documentation, obviously we carry out the know your customer requirements. Those KYC requirements. We have to carry those out. We have to know you. You can come to our office. We can discuss. We give you directions. We give you advice as necessary. And it is not. Many Kenyans do think that trust is just for really the super wealthy. That's not true. Like I said earlier, so long as the trust can actually take care of its expenses, that's just okay. But at least one thing that we always say, it is very important to do estate planning. So if in your own mind you feel it is not trust, or you don't qualify to set up a trust, then at least do a will. You don't want to leave once, for example, you pass on. You don't want to leave your family in a situation where there will be all matter of disagreements, and because we see this all the time.
Absolutely.
And we also see situations where wealthy people, they could be politicians. And 5 years down the road, all the assets are gone, and the children are living. They're living in very bad conditions, school fees and all that. But yet, when you are alive, you are wealthy. So estate planning is very important, and more importantly, setting up a trust, because you can do a will, yes, but you don't have control. You lose control the moment you do the will. You leave it to the people who you have willed the assets to they have all the freedom to do whatever they want to do with those assets. They can sell them. So the assets can be depleted fairly fast. But if you put it into a trust and give the powers to a trustee, they'll manage it in accordance to your letter of wishes.
Fantastic. Because of time, this will be just mention briefly, Wakili, very briefly, when it comes to ancestral properties, can they be put in a trust or a will? As a closing remark.
Ancestral properties, you can only will away what belongs to you.
Okay.
So for ancestral properties, if you have the concurrence of members, the other beneficiaries of the family, and you decide to put it as in a will or in a trust, then that is okay. But the general rule, or the rule of the thumb, is that you can only will away what belongs to you.
Okay.
Yes.
Fantastic. Abel, parting shot, 20 seconds.
My parting shot is that all of us should have estate planning.
All right.
And I always believe that the best way, according to me, for wealth succession is to put your assets into a trust. So long as you have, I mean, we can talk of certain thresholds, but I believe once you attain the age of 40s and 50s, you've accumulated a fairly decent amount of assets. And you can then talk to a trustee. You can come and talk to us. We can advise you on how to do this.
Okay.
Yes.
We'll end it right there. Thank you very much, gentlemen, for making time. This was an amazing conversation, quite informative, quite enlightening. There we have it. Thank you so much for your feedback, the questions. I hope and trust that, you know, you've been able to get your solution right here on Family Matters Financial Clinic, where we call it a clinic because really you can see the kind of treatment we're giving you, right? So asante sana for the feedback. And remember, we are live on YouTube just because of your support, like I had mentioned earlier. So please go through our channels to enjoy a number of shows lined up for you, just like this one, and you can enjoy our previous episodes on Family Matters Financial Clinic, as well as other shows like Crosstalk, where we have matters politics, you know, deep down there. So we're not just about church. Then we also bring together a panel of experts to discuss the current affairs, state of the nation, state of the church, and how believers can actually transform the society. All this is made possible because of you, our partner, and you want to say a very big thank you, a very big asante sana. God bless you. And one other thing I need to mention is that support. Paybill number 316-316, and the account name is your telephone number. We also have a cooperative bank account, and the number is 0113-600-799-100. And thank you so much for being part of this conversation. Tomorrow, we wrap it up with the matters relationship. We'll be discussing about the empty nesting. And again, happy International Men's Day, and I'm glad I had men in studio with me. Bye, and God bless you.